In this video, I'm going to be talking about dealing cocaine in Indiana. Dealing cocaine is a serious charge in Indiana, and there's serious penalties. It's also an offense that can be easily charged, and in fact, a lot of persons may actually just be in possession of cocaine, but because of circumstances surrounding the possession, they're actually charged with dealing, so they're facing a really serious offense. In this video, I'm going to be talking about that. I'm going to be talking about common defenses to dealing cocaine and what you should do if you or a loved one is facing this kind of charge. So about me, my name's Nathan Vining. I'm a criminal defense attorney here in Indianapolis, and I represent individuals in criminal cases throughout the state of Indiana. By the end of this video, you should know more about dealing cocaine in Indiana. So in any criminal case, one of the first things you need to do is look at the statute that you're being charged under. In Indiana, dealing cocaine is charged under Indiana Code 35-48-4-1.1, and it essentially says that a person who knowingly or intentionally delivers or finances the delivery of cocaine or a narcotic drug, pure or adulterated, or possesses with the intent to deliver or finance the delivery of, commits dealing cocaine and narcotic drug, which is a level 5 felony at its lowest. But cocaine in Indiana can be charged all the way up to a level 2. So you can see in Indiana, it's charged based on weight. If you're dealing under 1 gram, it's a level 5. If you're dealing over 10 grams, it can be charged as a level 2. So for instance, if you're dealing 1 and 5 grams of cocaine, but there's an enhancing circumstance, it'd be charged as a level 4 rather than just a level 5. So for instance, if you're dealing under 1 gram, but there's an enhancing circumstance, it'd be charged as a level 4 instead of a level 5. And this chart here essentially breaks down the different weights and the different levels that you're being charged. So sometimes if you're able to challenge the weight in a case like this, you could actually maybe lower the level of offense that you're being charged with. So look at the enhancing circumstances. You may be wondering what those are. Here is a list of what they are. They're things like dealing in the presence of a child, dealing on school property or on a school bus, or even dealing in possession of a firearm. So there's different things that are being penalized to a higher degree, and that's these enhancing circumstances. The penalties for dealing cocaine can also be serious. At the lowest, it's level 5, which is 1 to 6 years imprisonment. And at the most, it can be a level 2, which is 10 to 30 years imprisonment. So if you're facing a level 2 cocaine dealing charge in Indiana, you could be facing some serious exposure, and it's important to talk to an attorney. And there's really level 4 and level 3 between, which also can face significant amounts of jail time. So if you're charged with dealing cocaine, you're probably wondering what you need to do. And there's a few different documents you need to review if you or a loved one is facing this kind of charge. And the first kind of document is the charging information. You want to find this charging information and take a look at it. This charging information lays out the statutes that you're charged under, so you can see if you're being charged based on weight, or if there's things like enhancing circumstances at play that are enhancing the level of your charge. The second document is a probable cause affidavit. This is the document that lays out the facts that outline why the state believes that you were dealing. So you get essentially a summary of what the state would be trying to prove if you were to go to trial in this case. And the third, you may not have this at the initial outset of the case, but once you get it, you're going to want to review it. And that's the discovery. That's the evidence against you. So you're going to see what the state has against you and see what they're using to try and prove that you committed the act of dealing. So these are 3 things that if you're dealing with this kind of case or a loved one who's helping somebody through it, you're going to want to review these documents. And right here is a sample charging information for a cocaine dealing case. And you can see here on count 1, the state is saying that on or about a certain date, this person did knowingly or intentionally possess the intent to deliver fentanyl, pure or adulterated, which is a narcotic drug. So this is the count 1 is they're charging dealing with a narcotic drug with a weight at least 10 grams. And then count 2, the state is charging that this person on a certain day did knowingly or intentionally possess cocaine, pure or adulterated, weighing at least 10 grams. So this is what the state is charging, what they're saying you did. You're then going to want to go to the probable cause and review what that summary is of the story to see what they're alleging actually happened. So the next thing we're going to talk about is defending a cocaine dealing case. There's a lot of different defenses that are available to a person in this case, and we're going to talk about some things that you, as you're reading over this documents, would want to think about and talk to an attorney about. So the first is that a lot of times a dealing charge in Indiana is based on the inferences. It's based on the fact that they found drugs and are looking at the things and they're looking at the circumstances surrounding how they found those drugs to say that we believe this person is dealing, and as such we're going to charge that. So in this kind of case, what they'd look at is the amount of drugs. We would look at how it's packaged. A lot of times, if a person is a dealer, the drugs are packaged in small baggies so they can be easily distributed. They're going to be looking to see if there's cash, because there's a lot of times cash around drug transactions. They're going to look for multiple cell phones, and if there's guns present. It's challenging because a lot of times a person may just be in possession of drugs, but the state is looking at things like these 5 items and saying, well, since all of these things are present, we believe this person is dealing, and they're charging it. So it really increases the potential penalty if somebody's in this situation. There's also some common fact patterns that we see a lot. Those are Terry stops, traffic stops, and controlled buys. So the first common fact pattern would be a Terry stop. And what a Terry stop is essentially, it means that somebody is traveling, typically by foot, and they're stopped by an officer because the officer has reasonable suspicion to believe that there's some kind of criminal activity occurring. So if there's a drug dealing case and it's based on this kind of a stop, you're first going to want to look to see if the officer did have reasonable suspicion and what were the circumstances that caused them to have reasonable suspicion, and actually determine if they were reasonable. So you're going to want to see if you can attack that. The second situation is a traffic stop. Traffic stops can be challenging because there's a lot of different elements at play. And first, you're going to look to see, was the stop valid, and did the officer have a valid reason to stop you? A lot of times it could be something like speeding or a traffic infraction, but there are circumstances where there wasn't a valid reason for the stop, and you can challenge the following search based on that, and you can move to suppress that evidence. And what that means is that you would argue that the state couldn't use that evidence against you because it was based on an illegal stop. The next thing you're going to want to look at is whether or not there was consent to the search or why the officer searched. For instance, you were just pulled over for speeding. How did that lead into a search of your vehicle and the ultimate finding of drugs? There needs to be some kind of reason why the officer believed that there was a reason to search the car. With that, a lot of times there may be a canine involved, and that's another thing to look into. And when this kind of situation, you're going to see, was it the officer that stopped you that had the canine, or did an officer arrive with the canine that did a free air sniff? The officer can't just have you sit there waiting for another unit to arrive with a canine for an unreasonable time period to conduct this search. And the last circumstance is controlled buy. The controlled buy is where the officers work with a confidential informant and set up a controlled purchase of the drugs. Here the officers do as much as possible to control the environment, so they're not only relying on the confidential informant's testimony. They do things like track the money being used to purchase the drugs, have recordings, they do the drop off and pickup. They're doing as much as they can do to control the environment to show that it's reliable. That's because there can be a lot of credibility issues. So if you're dealing with a controlled buy situation, you want to look to see if there's ways you can see if there were issues with how the detectives conducted the controlled buy. And then you're going to want to look at the credibility of the confidential informant. A lot of times these confidential informants can have credibility issues. For instance, maybe they have previous convictions that show they have a propensity for lying, or they cut a deal with the state for favorable treatment for doing this, or maybe there's a bad history between you and the confidential informant that would give them reason to lie or not be truthful in this situation. You're going to want to see if you can attack the confidential informant's credibility. There's also some other challenges you can see commonly in a drug case, and that's challenging the weight. If you can challenge the weight of the drugs, you could potentially reduce the level of offense being charged. You're going to want to look to see if the state can prove enhancing circumstances. And then there's also knowledge and intent. You can always attack knowledge and intent because you have to know or intend to be doing the act of dealing. So for instance, if you're driving a vehicle and you're pulled over and there's drugs in it and you're ultimately charged with dealing and you had no clue, you could attack the knowledge and intent. So these are just a few of the different ways you could challenge a drug case. So those are a few different ways you can challenge a drug dealing case in Indiana. If you have questions, you can feel free to give me a call or text. I'd be happy to take a look at your situation. In a typical consultation, what we do is take a look at your case and talk about the different steps that would go along in that case from start to finish to give you a plan as to what you should be looking at in your case and what we would do in those situations. So maybe we would identify issues with a traffic stop or things that you need to look into further. So again, if you have questions, feel free to give me a call or check out my YouTube channel. I have more videos on drug dealing offenses and the court process in Indiana.